This is David Black. I'm a criminal defense lawyer in Phoenix, Arizona. Somebody comes to me and they say, David, I've been charged with a DUI. What should I do? Here are some basic things that I would use to analyze their situation. So the first question I ask is, was there a reading of your blood, breath, or urine? I say urine because it's in the law, but they very rarely test urine. So assuming it's an alcohol DUI, did they do a portable breath test? Did they have you blow into the intoxilyzer, which is that big machine back at the station where you do 2 blows? Did they draw blood? Did they do all 3 of those? Once you tell me that, I say, okay, well, what are the charges? A lot of times when you look at a ticket, you've been charged with DUI, you've got 4 DUIs and you're thinking to yourself, I only did it once, or maybe you didn't do it at all, but you did do it, or whatever it is. You can't be convicted and sentenced 4 times consecutively. So what happens is that you get, if you're convicted, you get convicted of the most serious crime, and there's no punishment for the other one. So it's not as though you're really facing 4 times the punishment. You would typically be charged with 0.08 DUI, which is the lower level, a 0.15 DUI, which is an extreme, and a 0.20, which is a super extreme, and then preceding all of those, 1 DUI, which is impaired to the slightest degree. That's what I'm typically looking at. What is the blood alcohol content? What is the method of testing? Was it breath or blood? And that's because there's different margins of error. And what were you actually charged with? So once I know that, I probably you're wondering, what can I do for you? And really it depends on more facts. So let's say that you are, you've hired me and I'm going to court for you, and the prosecutor wants you to plead guilty, and you're okay pleading guilty, but you don't want to plead guilty to the most serious count. You want me to get you something better than that. I'm going to first of all say that's a very reasonable and admirable request, but allow me to do my job. Let me talk to all of the police officers in this case. Let me look at the lab results. Let me talk to my expert if I think it's appropriate. Let me research some items. Let me argue an issue to the court. Okay, let's see. If it doesn't matter, let me go through literally everything I possibly can in order to get the best option on the table. Now, obviously, if you're not guilty or they can't prove that you are, and I can show that to the state, they'll dismiss the case, okay? But that's not what usually happens. What usually happens is we have a series of defenses that we've raised, and then we present them to the state. We hopefully get you an even more favorable offer, and then you, the client, decide, you know what, that I want to do that. I just want to be done. I want to do that. Or I don't like that. I don't think it makes sense. Either I'm telling you it doesn't make sense, or it doesn't make sense to you. Let's prepare for a trial. So a trial in a DUI case in Arizona is a jury trial. And here's what that looks like. Basically, however many months after retaining a lawyer, we've checked all the boxes, crossed the T's, dotted the I's, got the best deal we can on the table, and it still doesn't make sense for the client. We would then request a jury trial. On the day of trial, the jury would be selected. In Arizona, it would be 6 jurors. Usually they would have 1 alternate. And there would be a trial. It usually takes a day or 2 in a city court case. The state calls police officers. The state may call an expert. We usually call an expert of our own. We may call you to the stand. And then a jury decides, if there's proof beyond a reasonable doubt. So after a trial, there could be an acquittal. And a complete acquittal is amazing, and we've had them. And that means that everybody goes home and there's quite literally no consequence from the criminal charge. But let's say there is a consequence. As we know with DUIs, they're a challenge. They're hard to beat. Let's say you either pled guilty or you got convicted at trial. Here are the sorts of things that you might expect. So if your blood alcohol is above a 0.08, but not appreciably higher than a 0.15, you're probably looking at a day in jail in Arizona. If it's higher than a 1.5 and not appreciably higher than a 2.0, you're probably looking at 2 days in jail and 7 days of what they call home detention. And then if you're above a 2.0 or substantially above a 2.0, you're probably looking at 3 days in jail, 11 days in home detention. For those extreme and super extreme counts, the court actually requires an ignition interlock in your car. If you're just convicted of a regular DUI, you will have to get an ignition interlock for a minimum of 6 months, but the court won't monitor that. There are all sorts of breaks that went into place 10 or so years ago. So it used to be the case that a first-time DUI was 10 days in jail, an extreme was 30, and a super extreme was 45. 45 literal days in jail. When I was an undergraduate at college, had I gotten a super extreme DUI, I would have served 45 days in the county jail, and it would have been tent city, and I would have worn pink underwear, and it would have been embarrassing. Today, if you get a super extreme DUI, typically you're going to get the minimum sentence, which is 45 days in jail, but they delete a series of those days, 31 of those days. You're left with 14, and you only serve 3 of them in jail, and 11 can be done on this sort of ankle monitor / home detention thing. So there's also fines, alcohol counseling, those sorts of things. They really vary. They're case specific. I encourage you to call me. There are other factors that can be considered. Were you driving? Is there anything aggravating? Did you have any medical conditions? Are there any issues with the labs? And these are all things that we know that you may not know whether or not they're relevant. So please call me. It's 480-280-8028.